My name is Tom Bruce. I'm Head of Entrepreneurs and Investors here at Farrers. For those of you who don't know much about us, at Farrers our focus is on acting for private businesses, family businesses, entrepreneurs and investors. And so this week is therefore a key part in our year. We've been absolutely blown away by the engagement in the week. And as that first thing this morning, we had over 2,000 attendees signed up for what we expect to be a week of highly engaging and interactive events. So we're really thrilled to have you join us, and thank you for taking the time. Please do take a look at our microsite. Our link will be in the chat bar to find out everything you need to know about the week, to sign up for more sessions, and to find out more about how we work with entrepreneurs and investors throughout the year. If you haven't already, please do sign up for the final session of the week on Friday at 5 p.m. It'll be an hour of non-alcoholic and alcoholic cocktail making and networking. We've got some fantastic prizes that have been donated by some of our clients. So please do have a look at that and sign up if you've got time. A few quick housekeeping points before we get started. So these masterclasses are all about you. So please do contribute to the chat, to the group discussion. There's plenty we can say, but our aim is actually to make sure that you get what you want out of the session, either during the session, or if you don't have a chance to ask a question or it's a particularly detailed question, please do follow up with us afterwards, and our contact details are on the microsite for all of the session leaders. Also, just to let you know that the session will be recorded, so we can share it afterwards. All of the recordings of the sessions will be posted on our microsite, so you can see them there, together with summaries of key takeaways from the sessions, so that we can build the follow-up and continue to add value to the microsite as we go. Just a quick one, keep yourself on mute unless you want to raise your hands or ask a question, just to make sure we don't get any feedback. And I really do hope you enjoy the session and enjoy the week, and it's fantastic to start it with so much engagement from all of our contacts and clients. That's enough for me. I'd just now like to welcome my partner and co-host for this first masterclass, Startup to Grown Up Company Law and Strategy. It's Mari Bates, and I'll hand over to Mari now to introduce the session.
Thank you, Tom, and welcome everybody to our first masterclass. As Tom said, this session is called Startup to Grown Up, and what we're looking at here is thinking about key considerations for growing businesses to be aware of. So these will start with matters around your governance, your structure, corporate strategy, and thinking about these things as your business grows. You know, some of these matters may not have been a priority as you started your business, as you grew your idea and developed your business in the early stages, and when you were looking at your sort of friends and family funding. But as the business takes off, then clearly we need to revisit a lot of these key corporate strategy questions to make sure that, you know, as you're getting your further rounds of funding, that your business is still doing what you need to do. So we'll be looking at some practical tips in areas of corporate strategy and structure. We'll be thinking about your compliance as your business grows, getting on top of some of these key areas that, again, you may not have focused on day one. Thinking about your team, and do you have the right people, and how do you protect the right people, how you're incentivizing them, and then, you know, making sure your property arrangements are working for you in relation to your strategy. So today on the masterclass, you have myself, Mari Bates, and Tom Bruce on the corporate side, with support from our tax colleagues. Then we have Alan Baker, who is from our IP and commercial team, Hannah Taylor in our employment team, and Hayley Wilson. So we look forward to talking you through some of those ideas. This should be an interactive session, so please do use the chat function at the bottom of your screen. If you have any questions, or if you want to share your thoughts and your experiences whilst we're speaking, then please do type them in. We really do encourage that. And we look forward to running through some of these ideas. So as I said, we'll start with some thoughts around corporate strategy, corporate structure, and on that basis, I invite Tom again to talk to us about the corporate structure, funding structures, and any thoughts he has around this as you go into growth phase of your business.
Thanks, Mari. So just outlining a few key initial thoughts around these items, and I should say that we've deliberately started the week with this session because it covers such a broad set of different areas. So for more in-depth analysis on some of these areas, we'll be highlighting the different sessions in the week. And if you're not already signed up for them, please do have a look on tax, on funding, on other elements, on employment, so that if you need to get some more detail on some of these areas, please do look at the other different sessions specifically on them. But just thinking very basically about corporate structure to start with, and of course there are different options. I've just identified 4, but we all know, I think, or we anticipate that most of the audience here will be sophisticated around private companies limited by shares. They're the most familiar, the most usual corporate structure for limited liability, and we'll focus on those companies, on private companies during this session. But just to be thinking about basics and key practical tips, Companies House filings, that's all moved now to an automated system online, making sure those work. Get your register of shareholders right, make sure that's always accurate. When it comes to investment, that's going to be the first port of call in terms of an investor understanding who legally are the shareholders of the company, getting your person with significant control, your PSC filings right. Just get those basics right. Have a look on Companies House. If there's anything that's not right there, get it sorted, and have a think about the online software to be able to link up your Companies House and other filings and registers of shareholders, directors, etc., because that can all be really quite neatly done now. And if you need any further thoughts on that, please do let us know. Private companies is one, public companies is another. We won't go into too much detail here, but for PLCs, just think about, we have international clients who look at that particularly and like the idea of the kudos of it, a slightly heavier weight. You're a public company or a private company, but actually just be wary of the stricter regulatory regime, particularly around needing to have at least £50,000 worth of share capital on day one, needing to pass or issue shares by an ordinary resolution of shareholders, or having a provision in your articles that does that. And contrast, for example, private companies where, if it is nice and simple, the board can issue shares. So it's just a little bit less flexibility around PLCs and things to be wary of. That's the second one. The third one, which I'll just touch on briefly, is a not-for-profit vehicle like a company limited by guarantee, which has members, not shareholders, and will have restrictions around how income and property can be applied. Charities are often companies limited by guarantee, but also think community interest companies. And in this area, also consider badges, so whether if you're social enterprise badge or B Corp, for example. We see a lot of companies now applying for B Corp status and focusing very much on sort of ESG elements there. So just something to have in mind. I'm going to hand over to John now, John Haley, who is a specialist in LLPs and partnerships at Farrers, and he's going to talk about the fourth option, which is setting up a partnership, and just key things to think about when you're looking at that.
Thanks, Tom. Morning, everyone. I'm going to be really brief here. I just wanted to, I suppose, a plea as someone who loves LLPs, not to discount them if you're thinking of setting up of a new business. They are really flexible vehicles. You can do pretty much whatever you want with them in terms of how you set up management, how you set up profit sharing. Real flexibility. If you can think of it, you can probably do it within an LLP. So they're a bit less constrained than companies. All of the stuff around registration at Companies House, etc., is pretty similar. Filing of accounts, pretty similar to the limited company, but you do have this additional degree of flexibility. What you don't have with LLPs is some of those early stage tax incentives, EIS, SEIS. So if you're looking at fundraising, they won't work so well. The thing that I think some people sometimes forget is it's relatively easy to move from an LLP model into a limited company model at a later stage if that's something you want to do. So that's all I wanted to say really, but very quick takeaway message is just don't discount the LLP if you're at that point still of thinking which model to use for your business. Thanks again. Back to Tom, I think.
Thanks very much, John. And I should say to everyone that we will follow up on the microsite after this session with a briefing note on different corporate structures. So choice of vehicle, what are the pros and cons, and we'll post that on the microsite after Entrepreneurs Week. So anything around corporate structure, you're thinking about yours or setting up a new venture, then please do refer to that note. Hopefully that will be a really useful resource that we will add to the microsite. The second thing I wanted to talk about after corporate structure is just think about funding, debt and equity, timing, type of investor, and just some key thoughts around that. And I should say before I start that we've got a specific session that Simon Ward and Martin Blake are running on Thursday at 11:30 a.m. on raising funding. So please do tune into that for a much more detailed dive into the pros and cons of different elements of this. But just some headline thoughts from me around funding, and it very much depends on the timing of where you're at in the life cycle of the business and the type of investor. So just thinking briefly about those things, early stage, if it's equity, it's private investors, it's family and friends, it's angel investment, tends to be ordinary share capital, aligning interests, so everyone is in there for capital growth, treating shareholders generally equally in terms of return of capital and income via dividends and voting rights. Debt at an early stage, probably less likely, unless it's needed to bridge a particular funding gap or shortfall, but may not be an option for the business anyway. I should say, though, we have seen a variety of clients using the government debt schemes, and I saw in the FT this morning that's all 4 of those schemes I think have been extended to the 30th of November. So we'll be looking at those debt schemes in much more detail on Thursday morning. If any of those are relevant for you, please do tune into that session. So from early stage moving forward, Series B, Series C, private equity, and other investors. I think about equity, preference shares tends to be a priority. So an investor might take shares that we paid out first, or potentially convertible debt at a discount, potentially particularly interesting now given valuations in some sectors, but generally with a 3 to 5 year period. Convertibles we find quite helpful sometimes, a little bit less focus on detailed due diligence, because there's that comfort around the convertible element, often secured against the company's assets. And then the debt at those later stages, often they can be highly leveraged transactions from investors with management incentives to hit key targets, etc. We'll come on and talk about more of that from a people management perspective. And then just contrast a trade partner or joint venture, sort of mix of funding, perhaps debt and equity. And just think about all of those elements in the round. As I say, we'll go into much more detail as we go, but I just wanted to set the scene with those to start with. We're now going to have David Gubbe, our head of corporate tax, just speak briefly to tax considerations on that choice of vehicle and company structure. David.
Thanks, Tom. Good morning, everyone. I'm not going to say too much on tax, save to say that, of course, the sooner a business is able to focus on its tax position and structure, the more likely it is it will be able to take advantage of a whole host of tax reliefs and incentives that may help it enhance its growth, attract investment, and potentially maximize value on an ultimate exit. So this will include considering matters such as which type of entity should be used. The company is the default entity, but as John Haley mentioned, the LLP is a useful, very flexible vehicle, one that I quite like from a tax perspective, because the LLP is tax transparent, meaning it's not taxed itself, and also because the members of the LLP are treated as self-employed for tax purposes, which can lead to quite a lot of advantages for them in terms of their profit share and indeed in getting a share of the equity in the business. Another factor is, of course, how should your group be structured? So can any part of your business or its assets, such as IP, separate trades, be held or developed in separate and possibly offshore entities? Not always easy, but for the right business and the right shareholder base, that may be achievable and may indeed aid an eventual exit. Tom's mentioned already an issue about how the business should be capitalized and the choice between loan finance and equity. The former, from a tax perspective, will generally give rise to tax deductible interest, which could reduce profits, taxable profits, subject to various restrictions. But of course, there may be tax incentives available to the founders and the investors in the business for equity investments they make. And indeed, our second session this morning at 11:30, which I'm hosting with my colleague James Bromley, will focus on this topic. Another key issue from a tax perspective is how to attract and incentivize your employees, ideally using tax advantage, share option, and equity arrangements. And we'll be looking at this in more detail on Wednesday morning. And then just a final point to mention is, of course, looking forward, how might one structure a future exit? And does anything need to be done now that would allow you to take advantage of tax mitigation or tax relief that could be available on an exit? So a number of tax-related issues to always bear in mind. That's it from me. Thank you, and I'll pass back to Tom.
Thanks very much, David. Now I'm going to pass over to Mari, who's going to focus more on your constitution, what that looks like at the moment, and making it work for you.
Thanks, both. And I suppose this does tie in quite closely with everything we've just been hearing about funding and structure, because ultimately your constitution does have to work for what's happening there. But taking a step back and thinking about your constitution more broadly, we've asked these questions on the slides. Do your articles allow your business to run effectively? Does your shareholders agreement still make sense for the business? And do you need to update these documents or your strategy as the business grows? And I suppose these are sort of broad questions about your constitution, and it sits at the heart of how you operate your business. So that the articles and your shareholders agreements, if you have one, are very important and are documents that you should continue to revisit as your business grows. The first thing I'd like to talk about around your constitution is the basic question of, well, are you familiar with it? It may be something that you just put in place quite quickly when you incorporate your business, and you might not have looked at it for a while. But just a reminder, really, it sometimes gets forgotten when you're busy running your business, that actually your decision-making procedures are outlined in these documents. Protections for your shareholders are also set out here. So ask yourselves, well, have you been abiding by what's in those documents? And that's quite important. If not, make sure you revisit these and familiarise yourself with what's inside them. At the most basic level, and this goes back to what Tom was saying at the beginning, have you been keeping your corporate records up to date and your statutory books in order? Do you minute your decisions? And if you're not really sure, then now, as your business grows, you're thinking you might look into funding, then now is the time for you to get your house in order with some of your basics around your corporate obligations. You might ask, well, why does this matter? Well, if you haven't been abiding by your constitution in making key decisions, you could actually risk challenge from shareholders. Actually, often shareholders might not think it's worth pursuing a dispute until the business is really worth something. So these things come out of the woodwork at a later point in time when you're getting a further funding round and when there's really money to be made from this. So it is important to do things properly at the outset, because the consequences can be more serious when the business is worth more and shareholders are looking for you to looking to recover anything that they feel has not been allocated to them properly. Another reason why it's important is, of course, an investor will want to see that your house is in order. So, again, at a basic level, just make sure that your corporate filings are in order, and that your books are there. If an investor comes along and wants to do their due diligence, so that's, as I say, that's the basics. And the next question, well, is the constitution working for you at the moment and as you grow? And when I talk about the constitution, again, just a reminder, this is your articles of association, which is your constitution in the public domain, and if you have one, your shareholders agreement, which is your separate contractual arrangements as between your shareholders. Are these working for you? And what do I mean by that? Well, do they allow you to make decisions effectively? Does the board make most of the decisions, or do the shareholders have reserved rights? It is common for shareholders to have reserved rights over and above what basic company law requires, but have you reserved the rights for them, or are you in a position where potentially quite a minority shareholder is maybe hindering growth? If they can block fairly important matters such as fundraising. So want to revisit, and we might come on to this around the discussions, but how do you go about adjusting those positions that some of your minority shareholders might hold, if they are going to hinder growth? It's something that Tom and I come across quite often. Other things covered in your constitution could be things like shareholder information. Are you obliged to share certain information with your shareholders? Again, is it the right level of information you're sharing? Again, we want to get the balance right, and you want to ensure ongoing engagement with your shareholders. So are you providing them enough insight into your business so that they feel engaged, that they're bought in on your strategy, and will help you get to where you need to? I suppose linked to that, if they are getting a substantial amount of information, then does your shareholders agreement include the right restrictions on them? So say include non-competes or confidentiality obligations in those documents to ensure that even after they have sold their shares, that there's a level of protection for you in the value of your business. So now is an opportunity as you grow to revisit your constitution and just make sure you're familiar with those and have a bit of a health check to see if it's working for you. Thinking about how do you need to evolve these documents as you grow. Again, I suppose at a basic level, does the constitution allow you to adapt and change your business plan, or do you need shareholder approval? And again, that builds into the concept of bringing your shareholders along with you. Do they allow for you to bring in fresh financing? And if they don't, then again, think about whether you need to change those. And these sort of questions do become more pertinent as new investors come onto the scene. And it is quite right that you will be looking to change your constitutional documents as you grow. A lot of the work that Tom and I are involved in is helping businesses that face their next really substantial growth phase and bringing in new investors, and the expectation of investors might not be entirely aligned with what your current shareholders might be thinking. And Tom, I mean, have you had experience of this recently? And do you have any thoughts on what sort of parts of the constitution you might want to be looking to change, or what the expectations of an investor might be?
Thanks, Mario. I think it's very often around control and just thinking very carefully about what level of control you are content with your investor taking, and whether that amounts to an interference with what we might describe as a sort of day-to-day control of ordinary course matters, or whether it is something that is more fundamental than that. For example, whether the financial thresholds of decision making, for example, around debt or employment contracts or whatever it might be, are you comfortable with the idea of going to your investor or a representative of the investor, say, yes, is this okay, and how regularly will you do that? And what is your relationship like? And the relationship is so fundamental, and it will vary from VC house to private equity house and because they are taking different approaches in terms of how they see the things. So I think control is a really, really important one, making sure that doesn't interfere with how you want to progress things, making sure you feel you have the right relationship and that you are aligned on strategy. Yeah.
No, I completely agree. And I think, what's interesting is there is no right answer as to what that right level of control is. But I think you're right, Tom, that mentioning that relationship is fundamental, and almost, the documents need to follow that. But I think that sort of feeds into this idea that it is a two-way dialogue when that new investor comes in, because you need to make sure that they are the right fit as well, and the constitution helps you get there, because you make sure that they have the right you're giving them the right level of control and seeding the right level, but actually with that you need to do your due diligence on your investor, and that's a two-way process as well. Of course, the investor does a whole host of due diligence on your business because they want to make sure that it's the right business for them. But it's right that you ask them, well, what are you bringing to the table? Do you have the right experience? Am I ceding control because you are bringing a wealth of experience in the sector to the table as well? So I think the way that your constitution develops as you grow, it really ties into that partnership that you'll find with your fellow investor as that develops. So yeah, as I said, that sort of thing we do see quite a lot of, and find that there's a huge amount of negotiation, but remember, there is no right answer, and it's all up for negotiation.
I think that's right, Mari. And one of the things that I see a lot of is during that negotiation process, founders and entrepreneurs learning a lot about what sort of partner they thought they were getting and what they might actually be getting, and not to just continue with that and be steamrolled on particular points if you're feeling uncomfortable. Of course, that depends on how dire or how badly the funding is required, but not to proceed if during that negotiation process the approach being taken is as a sort of, well, of course we're going to be relaxed about this, of course we don't want to be involved in sort of day-to-day control, for example, but then the documents reflecting something completely different, and just being very, very wary of what ends up being put on paper versus the sort of friendly upfront discussions that you might feel that you're having, at least at the outset.
Definitely, and I guess the founder's role continues to be key, and not to forget that when your the makeup of your investor fundamentally changes. So yeah, these big periods of growth can be an exciting time for businesses, but it's one to tread carefully with, and make sure, as you say, Tom, your written documents reflect what you think your arrangement is with your investor. Great. So I think that's at this stage, that's what we wanted to say on the corporate strategy and aspects. And as I say, do set out any questions in the chat box, and there'll be time for questions at the end. The other area the next area we wanted to cover was thinking about your compliance, and I invite Alan from our commercial and IP department to give us his thoughts in this area.
Thanks very much, Mari. Yes, I've got 4 areas to speak to here. I'll try to address each quite swiftly. On the first of these, protecting your intellectual property, my first sort of subheading here is about brand protection. So depending on who you need to sell to, it can be worthwhile investing in some brand protection measures early on. And the UK actually provides quite a decent level of protection for unregistered trademarks, for example, your brand names or logos. But if you do need to take enforcement action against a third party with the same name as you, or who's ripping you off somehow, then registering trademarks is the way to go. And we normally recommend a trademark registration or 2 for your core business name and perhaps important logos or slogans, etc., in the territory where your business is headquartered and or in the territory where the majority of your customers will be. Another subheading here is about copyright. So that's a non-registrable right in the UK at least, and arises automatically in certain copyright works that you or your business produce. For example, literary works, meaning text essentially, which can include software code of relevance to some in this audience, I think. One particular point to note is that UK copyright law provides that copyright works created by an employee in the normal course of their work are automatically owned by the employer, whereas copyright works created by a third-party consultant or a contractor, i.e. a non-employee, will have to be assigned in writing to you or your business if you want to own the copyright in those creations, even where you've commissioned the work. So that's something just to address in your consultancy terms. Third and final heading under IP is confidential information and trade secrets, often thought about as a kind of soft IP. This is worth thinking carefully about. Do you have confidential information that gives you an edge over your competitors, or which at least potentially should be guarded more closely than other business or product information? Even perhaps within your own business, does everyone need to know, or is it only a few? And especially when collaborating with new partners. I would probably concede that an NDA, non-disclosure agreement, is a relatively standard agreement, but you should think carefully about how you define the confidential information you're seeking to protect and the purposes for which that information can be used, as well as whether the confidentiality obligation should be mutual or should flow only in one direction. It's also a good idea to note down, I think, using quite general descriptions, the particularly confidential information or trade secrets, if you like, which your business relies on as part of an IP rights register. And that can be useful to delineate IP rights that you could license to a new collaboration partner, or indeed perhaps one day sell to a purchaser of your business or its assets. My second heading here, commercial contracts. And I think the key thing there will be your terms of business. As a minimum, you need to have some robust terms on which you sell your products or services. And I think for smaller businesses, a balance has to be struck here between protecting yourself and minimizing key risks, for example, with caps on your potential liability to your customers, and being careful not to overcommit with warranties or service levels. And on the other hand, that has to be balanced against terms that your customers will actually be willing to sign, ideally without huge amounts of negotiation. So you can't be too tough until your commercial clout has grown a bit, I think. The other aspect of commercial contracts is not so much what you write, but what you review, what you might receive from others, your service providers' terms, for example, for cloud hosting services or payment services, including potentially physical terminal equipment and for online gateway services as well. In most cases, it will be obvious, I think, whether your business has any of that commercial clout to negotiate the agreements for those services with, for example, the big tech firms, the Googles and the Microsofts of the world. But in other cases, early legal input can ensure some relatively significant improvements to those contracts in order to protect you from a legal risk perspective. And even if the contract is offered on a take it or leave it basis by your suppliers, I think there are still one or two points that it's normally possible to negotiate, or at least review and note down, so that your potential liability exposure or obligations under those contracts are properly understood. And of course, there's a whole realm of other agreements that can fall within this broad heading of commercial contracts. And in truth, some of those are relatively standard documents that you could perhaps repurpose from another context. NDAs, website terms of use might be examples of that. But I would always recommend that as your business grows, you at least get those checked by lawyers or review them yourselves so that nothing looks too amateurish. I can usually tell within about 30 seconds whether an agreement has been drafted in a bespoke way or whether it's been copied and pasted from elsewhere. And so might your customers, your suppliers, or others. So don't be too cavalier, I think, about repurposing those commercial agreements. My third heading, data protection. This will be of more importance to some businesses than others. Indeed, if you're not using any personal information about living individuals, then it may be of no importance at all. But I think it's fair to say that data protection compliance, including understanding and applying the GDPR, is a key business risk and arguably an opportunity as well for most businesses today. GDPR compliance in a nutshell, bearing in mind the GDPR is 173 recitals and 99 articles long, but it essentially boils down to 6 or 7 principles for the processing of personal information. And of those, arguably the most important are transparency and accountability. Accountability involves understanding what personal data you have, what you do with it and why, and recording that in a way that's kind of auditable, really, so you can retrace your steps. And transparency involves explaining the why and the how of your data processing to the individuals whose personal information is affected. And your most important outward-facing GDPR compliance document will usually be your privacy notice, sometimes called privacy policy or privacy statement. And again, I can usually spot a poorly thought out privacy notice in a matter of seconds, and so will your customers or others who may be reading it, usually with a view to complaining about how you've used their personal information. So I think a focus on your privacy notice and making sure that's accurate and GDPR compliant is a good investment of your time, particularly if you're a more data-heavy business. Please also pay attention to data security. Ensure that you use data security measures, both technical and organizational, which are appropriate to the amount and the sensitivity of any personal information that you're collecting and using day to day. A little postscript to data protection on PEC regulations compliance. That's the Privacy and Electronic Communications Regulations. It's a slightly less celebrated piece of law that really goes hand in hand with the GDPR and regulates a couple of things of tangential but some importance relevance. So first of those is cookies, where you've got your website is setting cookies on people's devices. You just need to be clear about that and sometimes get consent to set those cookies. And the second thing is about direct marketing, where you are sending marketing or advertising material directly to particular individuals, particularly by electronic means, including email. That is something that the Information Commissioner is particularly concerned about and does tend to fine for where you do it wrong. In other words, contacting people on a large scale without their consent. So please do make sure that you've appreciated and understood those direct marketing rules and how they may apply to your business. Finally, commercial regulation. We use this term at Farrers, or at least I do, to distinguish it from financial regulatory matters. So it may be relevant to your business even if you're not authorised and regulated by the FCA. Perhaps the key area of commercial regulation is under consumer contracts law. If you're not simply offering products or services on a business-to-business basis, but you also have consumers as your customer base. And most of those terms of business with consumers will be subject to consumer rights legislation, which requires that your agreements are particularly clearly worded and fair for your consumer customers. And for example, that there are particular rules in there about time periods and payments for returning products, including well-known cooling off periods for products bought online. There are some other areas of commercial regulation, for example, advertising rules, regulation of competitions and prize draws, and even competition law, where you may suspect anti-competitive behaviour among you and your competitors. For example, if you're about to do a joint venture with a rival business, but they're definitely topics for another day. So I will leave it there, and I'll keep an eye on the comments in case you have any questions about any of the material I've covered. Back to Mari, I think. Thank you.
Thanks, Alan. And just to reiterate, really, I mean, even when we're acting on an acquisition or an investment on behalf of a client going into a business, these are core areas that you would be diligencing before you make an investment. And data in particular is one that we've really seen a real shift in market practice here as to the amount of interrogation that a buyer would do in this area. If there's any question mark over the integrity of the data, that really could go to value. So especially for businesses where a lot of the value sits in a customer list or its processes around personal data, that compliance is absolutely critical. And of course, same can be said about your IP. If the value sits in your IP or in key contracts, or having a particular license, then these 4 areas are really where value can sit in businesses. So absolutely essential that you have your house in order in these areas. So thank you, Alan, and I do invite you all to attend the session on Thursday around protecting your brand. So moving on, and another key area for your business as it grows is your people, your employees, and again, value. I'm sure we all agree that a lot of value sits within your people. So inviting Hannah Taylor to comment on this area.
Hi everyone. So there's an employment law toolkit session scheduled for tomorrow afternoon, which is going to go into all of these issues in more detail, but just to provide a few high-level points at this stage. So when you're starting up, we understand that you often just need help and expertise and you need it quickly. However, so you don't store up issues further down the line, it's important to consider what support you need and what type of staff member can actually provide that. So whilst it can be tempting to hire a self-employed contractor to give you flexibility, the nature of the relationship might actually mean that it's an employer-employee relationship, which is going to result in employment and tax issues you haven't factored in. And then crucially, once you've found that talent, it's worth taking the time to build your contracts of employment for the long term. Now, I appreciate at the beginning of the employment relationship, it seems slightly negative to focus on the end, but it's important to consider what will work best for your business when the employee does leave and how you can reduce the impact of the employee leaving as much as possible. So this will include, you can consider whether for business continuity you want a longer contractual notice than simply the statutory minimum, and whether you want the right to put the employee on garden leave during the notice period, particularly as you might want to use that to ensure you can shore up clients and suppliers in case that employee takes them elsewhere. And on that topic, you might want to include post-termination restrictions such as non-compete clauses or restrictions on poaching clients, employees or suppliers. And it's really important to keep these under review throughout the employment relationship. The basic position on that is that restrictive covenants are potentially void as an unlawful restraint of trade and therefore only enforceable if they go no further than is necessary to protect legitimate business interests of the employer. Therefore, restrictions need to be carefully tailored for each employee and your business. And so this includes thinking about the geography the restriction needs to be applied to, and considering, for instance, whether you actually need to restrict an employee from dealing with clients potentially that they just dealt with in the last 6 to 12 months in the business rather than all clients in your business. Confidentiality is obviously key, and while employees have implied duties of confidentiality, you need to think carefully about the obligations in your contracts. And lastly, as mentioned, if IP is crucial to your business, it should also be managed in the employment contract as well. And then finally, going on to the topic every employer is grappling with at the moment, flexible working. Now, even before lockdown, for many employees, flexibility is paramount, and specialised talent often want positions that allow them location independence and more freedom to build their own schedule. And if you want to offer that flexible approach to getting the talent, you still need to be mindful of your employment and health and safety obligations that remain in play, even if they're at home. And if you're allowing employees to work from wherever they want, you also need to consider the potential tax implications if they work abroad, but also the employment rights they might acquire if they're starting to work there full time, and what other obligations you might have, for instance, to register employees in that particular jurisdiction. And even if you don't plan to have a remote workforce, employees with at least 26 weeks continuous employment can make a request for flexible working under the statutory scheme. And there's also a duty to make reasonable adjustments to make sure workers with disabilities are not substantially disadvantaged. And so when considering these requests, you really want to consider it fully before refusing. And if you do, you might want to get some advice, but you also need to factor in the statutory procedure, and also whether refusing a request could be a failure to implement reasonable adjustments for disability or indirectly discriminatory. And we're going to be considering this much further in our employment toolkit session tomorrow, and I hope you can join us for that. For now, I'll pass back to Maury.
Thanks, Hannah. And I suppose, you know, linked to all of this is very much your premises, which we will come on to next. But I you know, a number of businesses very much are thinking right now about what does the world look like post COVID, and what working arrangements that we've entered into now will continue in the future. But sort of not rushing ahead too much right now, and just thinking about premises more generally. Hayley, do you want to talk to us a little bit about making your property work for you, especially as your business evolves and grows?
Thanks, Mary. Hi everyone. I'm going to be giving a very brief overview, as Mary said, of some of the property considerations you should have on your radar while growing your business. So I expect that a number of you will already have leases or short-term licenses in place for premises or shared workspaces. So I'm going to be focusing on what you should be looking at out for in your lease now and thinking about going forward. So I guess on the highest level, you must remember you are contractually bound by your lease if it's been entered validly, of course. So you should be aware of your contractual obligations and restrictions that are set out in your lease. For example, are you allowed to share with group companies, or do you have 24/7 access to the premises? Also, if you must follow the correct methods of varying or exiting your lease if that's what is required. So I suppose the most obvious consideration for a growing business will be your space requirements, and as Mary said, in a post-COVID world. Do you have enough space now? As you grow, will you likely need more space? Or perhaps, in light of COVID and home working, do you now need less space? Or envisage you will need less space in the future with a home working policy? Have you considered social distancing in the workplace and how much space you will require to accommodate that, even if less staff are going in? So depending on what way you are going, there are a number of potential factors to consider. So if you want to stay where you are, do you have an option in your lease to extend the duration, which will give you longer term security? Or if your landlord owns the wider building you are in, do you have an option to take more space in the building to cope with your expansion? You could think about negotiating a preemption right over specific space in the building so that your landlord has to offer it to you first before granting a lease of it to a third party. And just remember, with formal options and preemption rights, these are often only valid for a specific period of time, and if they're exercised, they will be subject to serving the correct period of notice. So just make sure that you know your dates. If you want to exit your lease, perhaps in order to move to bigger or smaller space, or because you intend to be fully home-based, you want to know if you have a break date in your lease. So break dates can either be fixed or they can be rolling. For example, you can break at any time after serving a certain period of notice. And just make sure you're aware of the conditions attached to your break right, as you don't want to be in a position where you lose it by not correctly executing it. So for example, serving formal notice and adhering to notice periods are very important, and the break is likely to be conditional upon rent being fully up to date at both the date of service of the notice and the break date itself. And there may be other conditions, such as vacant possession at the break date, or potentially even a penalty sum to pay. If you don't have a break date in your lease, you can look at negotiating a straight out surrender with your landlord, but the likelihood is you'll have to negotiate and pay a premium in order for them to agree to that. If you do need less space due to home working, for example, you could look at surrendering part only of the premises. Another option is looking at assigning your lease to a third party, but this is often not an attractive option for a new business, as you will likely need to obtain the consent of your landlord, and they will likely ask for you to guarantee the obligations of the new tenant under what's called an authorised guarantee agreement. So it's not really considered a clean break. Assigning a lease may be necessary though. So if you are staying where you are under your current lease and setting up a new corporate entity, or are switching from the current vehicle you have, you should be looking to assign your lease and the liabilities that go with it into the new entity. And depending on what your alienation provisions in your lease say, the landlord may be looking to ask for a rent deposit or perhaps a guarantee, and the tenant is obviously most likely to be responsible for the landlord's legal costs in consenting to that assignment. Quickly, another point to think about is that some leases do also require landlord consent for a change of control in a tenant corporate entity, so be aware of this on any reallocation of shares. The two other lease provisions, just to have in your mind, are the permitted use and charging provisions. On permitted use, has growing your business meant that you need your space for additional uses or are offering new services? Have a look at your permitted use clause in your lease and ensure you have the rights to use the premises for that purpose, or if you need to get landlord consent. And also ensure the premises has the correct planning permission for that use. On lease charging, if you're taking out debt finance and your lease is over 7 years in duration, your lender may want to take security over your leasehold interest. So does your lease contain an appropriate charging clause permitting this? You might need to get prior consent of the landlord. A lender will also want to ensure that there are mortgagee protection provisions in the lease. So in that case, in the case that you default on your obligations, such as rent, they can step in. So moving on, just wanted to touch lightly on the effects of COVID in the context of leasing, given that rent is often one of a business's biggest outgoings. It's obviously no secret that the pandemic has had a massive effect on the requirement for property, and it's had a crippling effect on those in the retail and hospitality sectors in particular. We have, however, seen over the last 7 months an encouraging level of dialogue between landlords and tenants are encouraged to be open with their landlords on how the COVID is affecting their businesses. And on the back of this, landlords have been more willing to offer payment plans, temporary rent reductions and deferrals. And another good option to consider is negotiating a rent-free period or a landlord contribution towards premises refurbishments in exchange for extending the term of your lease. So there are a number of legislative measures out there at the moment to protect tenants, including a prohibition on landlords to forfeit leases for non-payment of rent. That's under the Coronavirus Act. But on that, I would just remind you that this is a temporary measure, and unless you have agreed a concession with your landlord, that rent is still due. So that means that when the prohibition period ends, which has been just extended to the 31st of December 2020, the landlord could still enforce their forfeiture rights and you could lose your business premises. So if you're struggling with your rent at the moment, I suggest you open a discussion with your landlord now and try and get a payment plan put in place. Last but certainly not least, do plan ahead and budget for property costs. You want to think of such things such as SDLT for new leases of bigger spaces, landlord's legal and professional costs for consent to varying or surrendering your lease, as well as your own professional costs, of course. Fit-out costs for new premises, as well as higher rent, service charge, insurance, and business rates, which may now have gone above the small business relief threshold. So that concludes my quick run through. I'm happy to answer any questions in the chat box or offline. So I'll pass back to Maddie now. Thank you.
Thanks, Hayley. And as we all know, I mean, property has really been an area that has been in sharp focus during the pandemic. I mean, out of interest, and only if you want to share, can I ask the participants, if any of them have been looking at their premises arrangements directly as a result of the COVID pandemic? Do you want to raise your hand so we can see roughly in numbers if this is a live issue for our participants? As I say, only if you feel comfortable sharing, but if you would like to, you just click on your participants tab and there is a raise hand tab. So it doesn't look like anybody is doing this at the moment, but I mean, Hayley, is this, it sounds like this is a conversation you've been having with a lot of our clients at this stage, is that right?
Yeah, absolutely. And I'm pleased to say that at the most landlords are looking to kind of secure their tenant. They don't want to lose them, and they are willing to enter into some form of concession, whether it's a deferral or it's a negotiation that for an extension on their the duration of the lease, they'll give a rent-free or whatnot. So it's positive in a kind of doom and gloom situation.
No, great. Well, that concludes the sort of formal sections of this session. If anyone does have any questions they want to raise at this point on any of the points we've covered or any other key areas, we have a couple of minutes now. So again, please do raise your hand or do type in the chat box. Give you a half a minute or so to do that. In the meantime, Hannah and Hayley, thank you so much for your time. Alan as well, thank you. Tom and I would be delighted to answer any other questions we have, you might have around the corporate aspects. Our details are all there on the slide, so please do drop us an email. It doesn't look like we have any raised hands at the moment, so I think that's a good time to conclude the session.
Thanks, Marion. And just a finishing point from me, just to say we'll follow up with a note on choice of vehicle on the microsite. We'll follow up with some key takeaways on the microsite. And otherwise, I'd just like to thank everyone for their time and direct you to the microsite for the full programme. And if you haven't looked at any of the other sessions yet, and some of what we've said to you today has prompted you to think in a little bit more detail about any of these elements around startup to grown up, please do look at the schedule and sign up to any of the other sessions. At the top of the chat box, you'll see Alex has put in there the way that you can get in contact with us. And otherwise, please do drop us a line. We'll look forward to you being part of the week. Thank you very much.